When the U.S. Constitution was adopted in the late 18th century, the decision to include a Bill of Rights was a key point of contention. Some believed it was necessary to provide a list of rights to protect citizens against intrusion by the government. Others countered that such a list would be counterproductive, as it might limit the scope of rights in the United States to only those explicitly mentioned. In the end, the Bill of Rights, the first 10 amendments to the U.S. Constitution, was adopted. And as you should remember from our earlier videos, the Bill of Rights outlines the fundamental freedoms protected against governmental intrusion. The First Amendment protects freedom of speech and the press, freedom of religion, and freedom of assembly, as well as the right to petition government. The Second Amendment protects the right to keep and bear arms. The Third Amendment prevents the quartering of soldiers in homes. The Fourth Amendment protects against unreasonable search and seizure and requires a warrant before a search and seizure. The Fifth Amendment protects against double jeopardy and self-incrimination and guarantees due process of law. The Sixth Amendment outlines a variety of criminal due process rights, including the right to assistance of counsel, the right to confront witnesses at trial, and so on. The Seventh Amendment establishes the right to trial by jury, and the Eighth Amendment prohibits cruel and unusual punishment, as well as excessive bail. We explore the rights established by each of these amendments in greater detail in other videos, but interestingly, as originally drafted, these protections and restrictions applied only to the federal government, not the states. While many states had their own bills of rights included in their own constitutions, there was nothing in the U.S. Bill of Rights that prevented the state governments from violating these rights. In the early years of the Republic, for example, some states protected the right to trial by jury, but others had more limited protections. Indeed, in its decision in the case of Barron v. Baltimore in 1883, the U.S. Supreme Court ruled that the Bill of Rights did not apply to the states. Writing the unanimous opinion, Chief Justice John Marshall concluded that the first 10 amendments contain no expression indicating an intention to apply them to state governments. This court cannot so apply them. He continued, "The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the governments of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the power of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily applicable to the government created by the instrument. They are limitations on the power granted in the instrument itself, not of distinct governments, framed by different persons and for different purposes. In other words, in the opinion of the court, the Bill of Rights applied only to the national government, not to the states." But the passage of the 14th Amendment in 1868 began to change this view. Remember that the 14th Amendment was one of several Civil War amendments passed in the immediate aftermath of the Civil War and dealing with its impacts. The 14th Amendment had several provisions, but the important part for our purposes here is the second sentence of Section 1, which provides that no state shall make or enforce laws which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This amendment contains 3 provisions. The Privileges and Immunities Clause, which prevents states from discriminating against the citizens of other states. The Due Process Clause, which essentially extends the legal protections afforded criminal defendants in the Fifth Amendment to the states. And the Equal Protection Clause, which essentially requires states to govern impartially, and which echoes the sentiment of the Fifth Amendment. And it was the Due Process Clause of the 14th Amendment that opened the door for incorporation, or the application of the protections afforded by the Bill of Rights to the states. The courts have generally favored a policy of selective incorporation, meaning the court has applied the protections of the Bill of Rights on a case-by-case basis rather than as a process of general or blanket incorporation, which would incorporate the entire Bill of Rights all at once. And so the selective incorporation of the Bill of Rights has proceeded gradually. The first real case incorporating a protection of the Bill of Rights was the case of Gitlow v. New York in 1925. In that case, the Supreme Court ruled that the free speech provisions of the First Amendment applied to the states. 6 years later, in Neer v. Minnesota, the court incorporated freedom of press to the states. The Free Exercise Clause was incorporated in 1940, and the Establishment Clause in 1947, guaranteeing freedom of religion at the state level. And freedom of assembly and the right to petition were incorporated in 1937 and 1963, respectively. Fourth Amendment protections were incorporated in Mapp v. Ohio in 1961. Fifth Amendment protections against double jeopardy and self-incrimination were incorporated in the 1960s. And the various due process protections of the Sixth Amendment were incorporated by a variety of cases beginning in the 1940s. The Seventh Amendment right to trial by jury was incorporated for criminal cases only, and states are not required to provide trial by jury for civil cases under federal law. Eighth Amendment protections against excessive bail and cruel and unusual punishments have also been incorporated. The Second Amendment right to keep and bear arms was not incorporated to the states until the case of McDonald v. Chicago in 2010, when the Supreme Court ruled that individual self-defense provisions of the Second Amendment were the central component of the Second Amendment. This made the Second Amendment the most recent provision of the Bill of Rights to be incorporated. But two provisions of the Bill of Rights have not yet been incorporated. As previously mentioned, the Seventh Amendment's right to jury trial in civil cases has not been explicitly incorporated, nor has the Third Amendment's protection against the quartering of soldiers. This is mainly because cases related to this question have not made their way to the Supreme Court. So over the years, the vast majority of the protections afforded by the Bill of Rights have expanded not just to be protections from federal intrusion, but protection against state violations as well. But that's it for now. Please leave any questions you have in the comments section below, and thanks for watching. Bye.